Hi, I'm Gabriella Agostinelli with Berardi Immigration Law, and I'm here today to talk about some of our recent successes at the border. So first we had an L-1B that was a little bit tricky because this individual had a situation involving three factors. One, he was beyond the required or allotted 5-year period of stay that an individual in L-1B status can typically hold. So to get around that issue, we were able to show that he in fact lives in Canada, only makes temporary entries to the United States. We provided 12 months of utility bills and 12 months of payment in Canada, showing that, and also his entry, a list of entries into the United States. So being able to show that, we were able to indicate that he in fact was eligible for time beyond the 5th year. Next, we had the issue of the fact that he's a full-time exclusive contractor for the company in the United States. He does not get paid with a W-2, a T-4, or with pay stubs. Instead, the company in the United States makes direct payments into his bank account every month. So we included a letter from HR explaining that this is the setup, but he indeed is a full-time exclusive contractor for the company. And we also included copies of the bank statement showing his regular payments from the company in the United States. And lastly, we had the issue of specialized knowledge. Specialized knowledge in general is just really difficult. So what we did was show that he had the correct education. He has had significant experience working with a proprietary technology over which he was conducting training in the United States, that he had experience, and that he really had the credentials to be able to work with this proprietary technology, and we're glad to say he was approved for another 3-year period. Our other applications were TN applications, one for a computer systems analyst and the other for the management consultant. The computer systems analyst case was a little tricky also because in actuality this individual was working for a Canadian company and had a contract with another Canadian company, but in fulfillment of this contract he had to enter the United States to test some software. However, once we were able to correctly document the contract between the two Canadian entities, as well as indications from the vendors in the United States where the testing would occur, we were able to succinctly show the government that his activities did qualify as CSA activities, and he was doing hands-on work in the United States, albeit pursuant to Canadian contracts. He was approved for the required period of time. And lastly, we had a management consultant application for an individual who's been approved on 2 prior occasions, so that's generally a good thing. And we were able to show that, again, in this situation, there were contracts in place showing a need for him. This individual has significant experience in the solar energy field, which is a growing, burgeoning field that's ever-changing. And by being able to explain that this individual had the know-how in this ever-changing field and the experience to be able to back it up, he was also approved for the required period of time. If you're seeking help entering the United States, please give us a call.